On the morning of the 3rd of March 2026, two women who had spent the better part of a decade maintaining a public silence so disciplined and so carefully preserved that it had become the defining characteristic of their public identities, walked into a private legal chamber in central London and did something that no one inside the British royal family had done in living memory. They filed, not a press release, not a carefully worded statement cleared through palace communications and softened to the point of meaninglessness, not an anonymous briefing to a sympathetic journalist designed to shift public perception without creating a documentable record. A formal legal action, directed not at a tabloid newspaper, not at a hostile biographer, not at the American federal apparatus that had been releasing documents bearing their names for the better part of 18 months, directed at their mother. Princess Beatrice and Princess Eugenie, daughters of Prince Andrew and Sarah Ferguson, Duchess of York, had instructed their legal representatives to initiate proceedings against the woman who had raised them, protected them, and according to the claim now sitting in the hands of their solicitors, placed them directly and repeatedly into the orbit of a convicted sex offender, without their informed consent, and without the basic maternal duty of disclosure that the law and their own devastated trust now demanded she answer for. Before we begin today's royal update, I want to take a quick moment. Many of you watch these videos but haven't subscribed yet, and you don't want to miss the latest developments and fascinating stories from the world of royalty. Subscribing is completely free and keeps you up to date as everything unfolds. And while you're here, let us know, where are you watching from? Share it in the comments. It's wonderful to see viewers joining us from around the world. The news did not reach the palace through official channels. It reached it the way the most damaging royal developments always reach it, through a phone call to a senior aide who had not been briefed, from a source who should not have known, about a development that the institution had been given no opportunity to manage, shape, or position itself around before it became an irreversible fact. The reaction inside Buckingham Palace in the hours that followed was described by those present within it as the particular quality of shock that arrives not from surprise alone, but from the recognition that something has happened that changes the shape of every conversation that will now need to be had. King Charles was informed within the hour. His response, conveyed through a private secretary to the relevant parties, contained 3 sentences. None of them were made public. All of them, sources confirm, acknowledged the same essential truth, that what Beatrice and Eugenie had done was not impulsive. It was not emotional. It was the conclusion of a process that had been building with quiet and devastating deliberateness for considerably longer than anyone outside a very small circle had understood. Sarah Ferguson received notification through her own legal representatives at approximately 11 o'clock on the same morning. The document that arrived on her solicitor's desk outlined a claim that those with knowledge of its contents describe as narrow in its legal framing, but vast in its personal implications. The sisters were not alleging criminal conduct. They were not filing a claim that would require the criminal standard of proof or invite the kind of prosecutorial scrutiny that would pull the entire York family into a process none of them could control. They were filing a civil action centered on a specific and documentable failure of parental duty. The claim, as described by sources familiar with its substance, argued that Sarah Ferguson had knowingly arranged, facilitated, and in certain documented instances actively encouraged contact between her daughters and Jeffrey Epstein across a period of years, during which Epstein's criminal history was not merely available public knowledge, but had been the subject of direct and explicit communication between Ferguson and the sisters themselves on at least 2 occasions that the claims supporting documentation was prepared to place before a court. The lunch arranged 5 days after Epstein's prison release was not the entirety of the claim. It was the beginning of it. What made the legal action extraordinary, beyond the raw fact of 2 daughters taking their mother to court, was the nature of the documentation the sisters had assembled to support it. This was not a claim built on memory and emotion. It was a claim built on paper. The DOJ's release of the Epstein files across the preceding 18 months had placed into the public domain a volume of documented correspondence, email exchanges, and recorded communications that the sisters' legal team had spent months cross-referencing with private records, personal communications, and the testimony of individuals prepared to provide witness statements about what they had observed, heard, and been told during the years in question. The result was a supporting document described by one legal source as among the most comprehensively prepared civil claim foundations seen in a matter of this sensitivity and complexity. Ferguson had discussed her daughter's personal lives with a convicted sex offender. She had provided their whereabouts and schedules in direct response to his requests. She had arranged the Palm Beach lunch. She had maintained the relationship for years after the point at which, the claim argued, any reasonable parent exercising basic duty of care would have severed it entirely and ensured her children were never again placed in proximity to a man whose crimes against young women were a matter of public record. The documents said so. The emails confirmed it. And Beatrice and Eugenie, who had stayed silent for years while the world debated whether they were victims or participants, had decided that the only way to answer that question with the permanence and the legal authority it deserved was to walk into a courtroom and let the evidence speak for itself. There is a particular kind of legal preparation that announces itself not through the drama of its filing, but through the weight of what it carries when it arrives. The claim Beatrice and Eugenie placed before the court on the morning of the 3rd of March 2026 was not assembled in the weeks following a breaking revelation or constructed in the emotional aftermath of a single devastating disclosure. It was built across 18 months of methodical, disciplined, and deliberately quiet work by a legal team that understood from the beginning that the only claim worth filing in a matter of this sensitivity and complexity was one that the documented evidence could sustain without requiring a court to take anything on faith. Faith was not what the sisters were offering. Documents were. And the documents, assembled from sources that ranged from the DOJ's own federal releases to private correspondence that had never previously entered the public domain, told a story about Sarah Ferguson's conduct that the claim argued no reasonable legal interpretation of parental duty could accommodate or excuse. The foundation of the claim rested on the DOJ files and the particular sections within them that concerned Ferguson's direct correspondence with Jeffrey Epstein. Those files had been in the public domain long enough for journalists, researchers, and legal analysts to have mapped their most significant contents with considerable thoroughness. But the sisters' legal team had done something the public analysis had not. They had cross-referenced the federal documentation with a parallel archive of private records, personal communications, and contemporaneous witness accounts that filled the gaps the DOJ files left and transformed a collection of damaging but individually manageable disclosures into a continuous and documented narrative of sustained parental failure. The Palm Beach lunch was not presented in the claim as an isolated lapse of judgment. It was presented as the most visible point in a pattern of behavior that the supporting documentation traced across multiple years and multiple occasions. Ferguson had not stumbled into proximity with Epstein after his prison release and made a single catastrophic error that her daughters had been too young and too trusting to question. She had maintained an active, documented, and ongoing relationship with a convicted sex offender and had done so in ways that repeatedly and demonstrably placed her daughters within that relationship's reach. The email evidence was central, and its implications were considerable. The exchanges in which Ferguson discussed her daughters' personal lives in direct communication with Epstein were not presented in the claim as embarrassing coincidences or failures of judgment about appropriate conversational boundaries. They were presented as evidence of a pattern in which Ferguson had actively incorporated her daughters into her relationship with Epstein in ways that served her own social and financial interests without regard for the duty of protection she owed them as their mother. The exchange in which Epstein asked about Beatrice's whereabouts in London and Ferguson provided that information was examined in the claim's supporting documentation with the forensic attention of lawyers who understood that its significance lay not merely in what was said, but in what it revealed about the nature of the relationship within which it was said. A mother providing her daughter's location and schedule to a convicted sex offender in response to his direct request was not, the claim argued, an act that any reasonable interpretation of parental duty could characterize as anything other than a failure of the most fundamental kind. The financial dimension of the claim introduced a complexity that elevated it beyond the territory of parental negligence into something the legal team had framed with considerable care. Andrew Looney's public references to unexplained payments in the sisters' accounts connected to the Selman Turk case had circulated in the public domain without the documentary specificity that would have made them legally actionable on their own terms. But the sisters' legal team had spent 18 months pursuing the financial thread that Looney's allegations had identified, and what they had found, sources with knowledge of the claim's financial annexes confirm, was a documented record of transactions and financial arrangements connected to Ferguson's network of associations during the Epstein years that the claim argued had placed Beatrice and Eugenie in positions of financial entanglement they had not consented to, had not been informed about, and had not understood the implications of until the DOJ releases made those implications impossible to avoid. The claim did not allege that the sisters had knowingly benefited from criminal activity. It argued something more legally precise and more personally devastating. That Ferguson had used her daughters' names, their royal titles, and their social proximity as instruments within financial and social arrangements she had constructed around her relationship with Epstein without their knowledge, without their consent, and in direct violation of the duty of care that the law placed upon her as their mother. The documents supported it. The email record confirmed it. And the sisters, who had spent years absorbing public questions about their own conduct, while the conduct that had actually placed them in this position remained largely unexamined, had decided that the examination was long overdue and that the courtroom was the only place it could be conducted with the thoroughness and the permanence the truth deserved. There is a particular kind of institutional crisis that the British royal family has developed across centuries of navigating the gap between its public image and its private reality, a reasonably sophisticated capacity to manage scandals involving senior royals and the press, legal actions brought by outside parties against members of the family, the slow, grinding process of reputational rehabilitation following conduct that the public has found unacceptable. The palace has machinery for all of these things. It has protocols, precedents, and the accumulated institutional wisdom of an organization that has survived more existential threats than most governments. What it did not have, on the morning of the 3rd of March 2026, was a strategy for a legal action brought by two of its own members against another. The machinery that had been built to manage the monarchy's relationship with the outside world had no established procedure for the moment the outside world ceased to be the problem and the family itself became the battlefield. And the absence of that procedure was visible to those watching the institution's response in the hours and days that followed the filing, in a way that communicated its own story about how completely the sisters' decision had outpaced the palace's capacity to contain it. King Charles's position was the most immediately impossible. He had spent the early years of his reign attempting to draw a clear institutional line between the monarchy's future and Andrew's catastrophically damaged legacy, a line that had required considerable political will to establish and considerable ongoing maintenance to preserve. The sisters' legal action did not erase that line, but it redrew the landscape around it in ways that made its maintenance considerably more complicated. Andrew was no longer simply a disgraced former royal whose removal from public life had allowed the institution to manage the distance between his conduct and its own reputation. He was now the father of two women who had taken their mother to court over conduct directly connected to the scandal that had defined his downfall. The institutional distance Charles had so carefully constructed was not going to survive the legal proceedings intact. Every court document filed, every evidence disclosure made, every witness statement submitted was going to pull the York family's history with Epstein back into the public domain with a forensic specificity that managed institutional distance could not accommodate. Andrew's response to the filing was delivered through a spokesperson in language so carefully constructed that its careful construction was itself the most revealing thing about it. He was described as deeply saddened by the development and hopeful that the matter could be resolved privately within the family. The statement made no reference to the substance of the claim. It made no attempt to address the documented evidence the sisters had assembled. It expressed no acknowledgement of the specific conduct the claim described or the specific harm that conduct was alleged to have caused. It was, in other words, the statement of a man whose legal advisors had told him that anything more specific than sorrow and a hope for privacy would be used against him in proceedings that were already beyond his ability to influence or control. Ferguson's response was more personal and considerably more damaging to her own position. She issued a statement through her publicist describing herself as heartbroken and expressing her love for her daughters in terms that sources close to the sisters' legal team described, with visible precision, as exactly the kind of public emotional appeal that the claim's documentation had been specifically assembled to ensure a court would evaluate against a factual record rather than a maternal narrative. The palace's public silence in the days following the filing was not the silence of an institution that had nothing to say. It was the silence of an institution that had understood, with the particular clarity of people who have navigated enough crises to recognize the ones that cannot be managed through communication, that anything it said would either align it with the sisters against Ferguson and Andrew or align it with Ferguson and Andrew against the sisters. Neither alignment was available to an institution whose survival depended on maintaining the appearance of a family navigating difficulty with unity and dignity. So it said nothing, and its silence, read against the background of everything that had preceded it, communicated with devastating efficiency the essential truth that the palace's carefully maintained position of managed neutrality had finally reached the boundary of what managed neutrality could sustain. The family had gone to court against itself. And the institution that had spent years managing the distance between the York scandal and the monarchy's future had run out of distance to manage. There is a legal principle that practitioners who have spent careers inside courtrooms understand with a clarity that those outside them rarely appreciate. The most consequential moment in a civil action is not the judgment. It is the filing, because the filing is the moment at which a private determination becomes a public and permanent record. It is the moment at which the evidence assembled across months of quiet and methodical preparation moves from the controlled environment of a legal team's offices into a process governed by rules that no party to it, however powerful, however institutionally connected, however experienced at managing public narratives, can unilaterally control. Sarah Ferguson's legal team understood this on the morning of the 3rd of March 2026. Andrew understood it. The palace understood it. And Beatrice and Eugenie, who had made the decision to file with full knowledge of what the filing would set in motion, had understood it longer than any of them. They had not gone to court to win a judgment. They had gone to court because the courtroom was the only arena in which the documented truth of what had been done to them could be examined with the thoroughness and the permanence that every other arena had consistently failed to provide. The proceedings that will follow the filing carry implications that extend considerably beyond the immediate legal question of Ferguson's parental liability. Every evidence disclosure the claim requires will place into the formal legal record documentation that the DOJ files introduced into the public domain, but that the legal process will now subject to a standard of scrutiny and a degree of contextual examination that federal document releases cannot replicate. The email exchanges in which Ferguson discussed her daughter's lives with Epstein will be examined not as isolated communications, but as elements of a documented pattern whose full dimensions the claim supporting evidence is prepared to establish. The financial arrangements the claim identifies will be examined with the forensic attention of a legal process that has the authority to compel disclosure that no amount of institutional management or public relations strategy can substitute for. And the witnesses whose testimony the sisters' legal team has spent 18 months preparing will be examined in a setting where the consequences of saying less than the full truth are considerably more serious than the consequences of saying it. Ferguson's legal position is not without its arguments, and it would be both inaccurate and unfair to present the claim as a foregone conclusion. Her team will argue that the decisions she made regarding her daughter's exposure to Epstein were made in a context that the claim's framing does not fully or fairly represent. They will argue that the understanding of Epstein's crimes available in the years the claim addresses was not the understanding that subsequent revelations, documentaries, and federal prosecutions have since established in the public consciousness. They will argue that a mother making social and professional decisions for young adult daughters in a world where Epstein's full criminality had not yet been publicly established cannot be held to the standard of knowledge that the sisters' claim requires. Those arguments are not without legal substance. They will be made carefully and they will be made well, but they will be made against a documentary record that the sisters' legal team has spent 18 months assembling precisely because documentary records do not respond to contextual reframing in the way that human testimony can. The emails say what they say. The dates on them are what they are. And the gap between what Ferguson told the public about her relationship with Epstein and what the documents reveal about the reality of that relationship is not a gap that legal argument alone can close. What the filing has already decided, regardless of what the courtroom eventually determines, is the question that has followed Beatrice and Eugenie through every public appearance, every declined interview, and every carefully managed communication since the Epstein scandal consumed their family. They are not participants. They are not complicit figures whose silence reflects an unwillingness to answer for their own choices. They are daughters who were placed, without their informed consent, into a relationship with a convicted sex offender by a mother whose duty was their protection and whose conduct, the documented evidence argues, was its opposite. That is what the filing says. That is what the evidence behind it supports. And that is what the courtroom, whenever its proceedings reach their conclusion, will be asked to confirm in the permanent and unappealable language of legal judgment. Beatrice and Eugenie did not go to court to destroy their mother. They went to court because the truth about what had been done to them had spent years being managed, shaped, and strategically positioned by every party with an interest in its remaining incomplete. The courtroom does not manage truth, it examines it. And the sisters, after years of absorbing questions they should never have been asked to answer, had finally found the one place where the right questions would be directed at the right person. The filing was the verdict. Everything that follows is the proof.